This meeting of the Escambia County Board of Adjustments, March 15. Oh, okay.
Updated agenda for you. We have the wrong case numbers on those. I put 2022-03 and 2022-04.
Okay, I thought I saw that.
And I have these all separated.
What is this?
I have them all separated by case number.
Oh, good.
And I put the applicants on the top right corner.
Okay,
This will be for the first case.
this,
However, on the throughout the first case, some people want to speak on the last case. So in the top right-hand corner, I put both cases.
okay,
Good?
okay,
All right, give me 2 more minutes.
sure.
Thanks. Just to reiterate, if you guys plan to speak on any of the cases, please fill out a blue form in the back and turn it up to the table up front. Thank you.
This meeting of the Escambia County Board of Adjustment, March 15, 2023, is hereby called to order. With 5 members present, we have a quorum. Before we get into the agenda for today, the board has a procedural matter that it would like to discuss, and I'd like to call on board member Michael Godwin to address it.
Mr. Chairman, thank you, Mr. Chairman. As the board recalls, last week we faced we had an intervener in a case before us, and I have thought about this over the weekend, and I just had a brief conversation with our attorney about it also. As a procedural matter, Mr. Chairman, I think that it would be best and fair to all parties when we have an intervener that the petition for the intervention be after it's filed with the clerk, that it be distributed to us beforehand, and also any reports or other documents, documentary type evidence, that also be provided. The board can't really make an informed decision unless we have the opportunity to read all the evidentiary filings ahead of time. So it's really not fair to the intervener. It's certainly not fair really to the board or to any of the other two parties, or whatever parties, however there are, whatever number of parties there are, not to have gotten all the documentation. So, Mr. Chairman, I would just ask that if it is in order that we request the staff that when we're faced with this problem again, to ensure a full and fair hearing by everyone that is concerned with the particular case, that in the case of an intervention, an intervener, that the petition be filed and ahead of time, and also any supporting evidentiary matter, documents, they also be sent to us so that we will have the advantage of being able to have read them. We certainly, if we're presented a report and not having the opportunity to have read it, we can make an intelligent decision. And I would just ask that, in fairness to the board and the parties, that become the operating procedure for the staff, and that's my thoughts and request.
If I may interject, I think what you're saying, and I agree, in the event that there's a motion submitted after the agenda is published, or any other evidence may be submitted to the clerk, to staff, before the meeting, that it be distributed to the board members before the meeting. Is that?
Yes,
I don't think
that's
staff-
essentially in my,
Staff wouldn't have necessarily the ability to require any party, whether they're intending to intervene or not, to submit things ahead of time, but if they do, and staff has it, that it be distributed to the board.
Would it be necessary at this point for us to put that in the form of a motion?
No, not necessarily. I think it's sufficient just that staff be aware, in the event the clerk receives something that's filed by an intervening party after the agenda is published, that it be distributed to the board.
I would have two follow-up questions.
Okay.
One, would I need to republish my agenda with the intervener and any additional evidence? Because I can advise if I get an intervention, hey, if you have any evidence you plan on submitting this week, go ahead and set it now. Would I republish, or do I only send it to the board members and they have to even make a motion at that point saying if the intervener has standing and the evidence can be accepted?
Yes, I think that's something that they would need to address at the board meeting when they convene. But the information, the documents could be distributed ahead of the meeting so that they have an opportunity to at least look at them.
Without being published.
Yes.
and also it would give us an opportunity to be able to assess the documents. I mean, and in a way, it's not fair to any of the parties. The intervener presents a report and says, here's my report. I would like it to become a part of my case and for the board to give it weight. Well, we've never seen it before. And also the opposing parties can't cross-examine it because they've not had the opportunity to read it either. So that really would be helpful to everybody and, be much appreciated. Thank you, Mr. Chairman. That was my point. I think we've
Thank
pretty
you.
much
Thank
covered it. I just, Mr. Chairman, I'm like you and all the rest of the board, I'm sure we want every party to be able to have the opportunity to present its case to the fullest of its ability, and that it be a full and fair hearing for all the parties involved, and for us to be able to make the most intelligent and a decision we can about what's presented to us. So I'm hopeful that'll help us.
I believe it's duly noted in the minutes and will be adhered to diligently.
Thank you, Mr. Chairman, for the time.
Thank you for your help. Let the minutes reflect that we now have 6 board members present. Will the clerk please swear in members of staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions requiring or regarding their qualifications and ability to offer expert testimony? Seeing none. The BOA meeting package for March 15, 2023 with the Development Services staff's findings of fact has previously been provided to the board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion?
Motion.
We have a motion, we have a second.
Second.
We have a second. Those in favor signify by raising your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
And did the publication meet all the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
So moved.
We have a motion. Do we have a second?
Second.
We have a second. Those in favor signify by raising your right hand. Passes unanimously. Members of the board, have you reviewed the resume and transcript for the Board of Adjustment meeting held on January 12 and January 18 of 2023? Do we have a motion?
So moved.
Do we have a second?
I'll second it, Mr. Chairman.
All those in favor raise your right hand. Passes unanimously. Okay, Mr. Godwin?
The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and are made a part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development orders for site plan approval are final unless overturned by a court of competent jurisdiction, the state may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if the applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decisions may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions, or any aggrieved party, as defined by state law, may seek review of such decision by filing an appropriate pleading in the court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel will be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of the board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed requests to speak forms. We must have these completed forms for the public record.
All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Resolution 90-13 before a decision by the board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issues to please identify themselves and describe the communication. First case will be conditional use 2022-01. Board members, has there been any ex parte communication regarding this case? Seeing none. Does anyone have knowledge or information obtained from a visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium and identify yourselves and state your name and address and be sworn in for the record.
Good morning, Meredith Bush, 125 East Intendencia Street, Pensacola, Florida, 32502. And I'm the agent for the property, an attorney for the property owner.
You're an attorney?
Yes, sir.
Okay, you won't need to be sworn. Thank you.
Before the board addresses the merits of this case, I just wanted to give you the background. You'll see there's an order in your packet, and I apologize, I've not had an opportunity to advise you of this before this meeting, when it's now back on the agenda. But you may recall, this case came before the board in January of 2022. It is a conditional use request that was for on-premises alcohol consumption within 1,000 feet of a religious institution. It was denied by this board, and it was then appealed by the property owner to circuit court. On February 1st, the circuit court issued a ruling granting the appeal, quashing the board's decision, and remanding the case for further proceedings. So it has now come before you again.
Would you like to state your position at this time?
Absolutely, thank you, sir. As Ms. Huell has advised, the circuit court reviewed this board's action in the transcript and the prior proceedings and has determined that there was no competent substantial evidence to support the denial, that everything that was presented at the time of the hearing supported approval of the conditional use application. So we're back before you today just asking that you take into consideration the court's order and approve the conditional use application. It is for alcohol service at a restaurant, but it is within 1,000 feet of a place of worship.
Board members, any questions of the applicant at this time? Thank you. Staff? Your presentation, please.
Absolutely. Ms. Christina, we'll go through that.
Okay, so this is for case number, let's start with the maps. Okay, so here is your location map for case 2022-01. Here is a future land use map. This is a 500-foot radius zoning. The aerial map. And this is the sign posted on the property. This is looking east along 9 Mile Road, looking onto the subject property, looking south across 9 Mile Road, looking west from the subject property. Okay. Don't need to read the address. Okay. So starting, this is a conditional use request to allow for alcohol on-premise alcohol consumption within 1,000 foot of a place of worship. Criteria A. The applicant proposed that the hours of operation for the restaurant are tentatively between 10 a.m. and 10 p.m. The 1,000-foot minimum distance is not achieved. There are 2 places of worship that are in the vicinity of the proposed use. See the aerial map. The buildings will be visible to each other. Alcohol consumption will be limited to indoors. On-premise alcohol consumption is limited to inside the existing restaurant building. As stated by the applicant, no outside consumption of alcohol is proposed. There are conditions or circumstances that would help mitigate any incompatibility. The proposed use will be indoors. The proposed use will be indoors. For criteria B, facilities and services. Facilities and services for the restaurant are being developed. There are services to the site and provide adequate capacity for the proposed use. There is an ECUA force main located directly in front of the property. Potable water, sanitary sewer, and solid waste disposals are all available to the site. Criteria C, on-site circulation. The existing ingress and egress for the site will be utilized. The applicant will need to submit the necessary FDOT driveway connection permits or safety upgrade permits as may be required. Criteria D, nuisance and hazards. The proposed use should not generate unreasonable noise, glare, dust, smoke, odor, vibration, electrical interference, or any other nuisance or hazards for the adjoining properties and other properties in the immediate area. Criteria E, solid waste. Solid waste services will be provided to the site. All on-site solid waste containers will be appropriately located and screened from on-site visibility. Criteria F, screening and buffering. The project will need to be approved through the site plan review process and meet the DSM design manual criteria for screening and buffering between uses. Criteria G, signs and lighting. The proposed signage and lighting will be assessed during the site plan review. Lighting should be directed inward to avoid impact to the adjacent properties. Criteria H, site characteristics. Based on the applicant's submitted plan for development review pre-app, the size, shape, and location of the parcel will accommodate the proposed use. Criteria I. The parcel is LDMU zoning district, which allows for restaurants, including on-premise consumptions of alcohol beverages. And the staff findings are staff recommends that the board approve the proposed conditional use as requested.
Synopsize for me why a alcohol place would be allowed with the objection of two churches.
The best way I can explain this is to read for you from the judge's conclusion. If you'll recall, at the last meeting, there were quite a few speakers who came, and the board apparently made the decision based on the speakers. The judge's conclusion says, in summary, the court finds the BOA departed from the essential requirements of law when it denied petitioner's conditional use application, as it did so for reasons not identified in the plain language of Escambia County's code. Respondent's denial of the conditional use application was not based on competent substantial evidence, but instead on speculative opinion and irrelevant testimony. The criteria of the case are what needs to be addressed, and my understanding of this is the court's ruling was the Board of Adjustment did not rule based on the black and white criteria, but on public opinion.
Board members, any questions of staff? Any questions of the applicant?
Mr. Chairman,
Yes, sir.
unless somebody else, I had one. Is there buffering planned for this development?
Yes, and it will need to meet the requirements of our code. It is a conditional use, therefore this board can apply such conditions as you deem necessary to include adding to any sort of buffering requirements. That's completely within this board's purview.
That cover it?
Yes. Yes, sir, I think so. Do have any idea what kind of buffering that we could ask for?
We're going to pull up the submitted site plan. And in the application regarding screening and buffering, it does say to please see attachment 1, proposed site plan. Appropriate landscape buffering will be provided. Again, Any additions beyond the minimum requirements of the code are within your purview today.
Isn't one of the property lines, doesn't it share it with one of the churches involved?
Can we go, oh, never mind, I got it on my laptop, it does. To the west, it's the property to the west.
I understand, Drew, that one of these buildings is gonna be a retail use and one is gonna be a restaurant use, is that correct?
So what you see on the site plan is a proposed, relatively small strip-type center. The uses allowed in there would be the ones allowed by the zoning. So yes, one of those proposed uses is a restaurant that would like to be able to serve on-premise alcohol.
And the other building will be a retail?
E-
Or you don't know?
That's our understanding. I mean, we don't mandate their business plan on exactly what would go into which piece.
There won't be, will there be, a carry-out or of alcohol or anything like that, or will the proposed development just provide alcohol within its the confines of the restaurant?
I would let the applicant's agent speak to that.
So, it won't be any different than any other restaurant. They won't be serving alcohol to be carried out. It would be to come in to sit down to, you know, if you have a beer or wine with your meal and then leave. It's not a bar, not a nightclub, just a straight up restaurant that allows service of alcohol. And there is an existing fence between the property and the church next door. And the applicant would be happy to, you know, buffer in any other way that the board deems necessary.
Do you know if the existing boundary line, I understand there is the fence, are there vegetation, trees, bushes, and all that sort of thing there along the fence?
There may be some, I'm not sure how dense it is.
Is that the fence we're talking about in this photograph on the right, left?
Yes, sir.
And the applicant would not be averse to leaving a strip of, along the fence, undeveloped and with trees, bushes, whatever landscaping we can, that would provide more of a buffer between the two.
So I'm not sure exactly how far the buildings are set back from that fence, but assuming that the property will accommodate the layout, whatever space there is between, you know, in that setback, then to add vegetative buffering would be fine. Trees or bushes or whatever.
I would just caution the board on anytime we start talking about using existing vegetation for buffering, things grow where nature wants to be. That isn't necessarily where a man-made design would go. Quite often, sites are stripped down to the bare ground and then built up, and the buffering added at that time to give it a uniform condition.
Any other questions of the applicant?
I have a question for council.
Okay.
I'm not clear on the legal issue here. I'm sort of understanding that the court has decided that the 1,000-foot minimum is not an acceptable part of our requirements?
No. No, that's in the county's code. The judge decided that the denying the conditional use was not based on competent substantial evidence at the previous hearing.
Meaning that we didn't use the 1,000-foot
No,
requirement to make our decision?
no, that there wasn't any competent substantial evidence to support the decision that was made. And it was denied based, I think, on, there were three criteria identified, and I don't recall exactly which. Let's see.
D, F, and
D,
I.
F, and I. Screening and buffering, additional use requirements, and nuisances and hazards. So those were the criteria identified, and the court concluded that of all the evidence in the record, the only competent substantial evidence supported granting the conditional use.
And if I may, so at the last hearing, both the applicant presented, our testimony and evidence in support of approval, and county staff presented their findings all in support of approval. The county staff being experts in the field, which they've done so again today, presented testimony and evidence in support of approval. At the hearing, the only other evidence that was presented were from the church members and neighbors who simply objected, saying, we don't like alcohol, we don't believe in alcohol, we think this is bad. And what the court said is that's not sufficient. You have to look at the criteria in the code, which are met and established by the expert testimony that's presented and by the applicant's presentation. And so simply having members of the public say we object is not enough to overcome that. That's not competent and substantial evidence.
So,
Sorry, go ahead, that's fine.
I was just gonna, so only experts can provide opinions, opinion testimony. So speakers, public speakers can come and they may provide fact-based testimony that can be considered competent substantial evidence. But in the court's opinion, the record showed that all of the speakers only presented opinion testimony, which is not competent substantial evidence. And that was the only other evidence that the board could have based its decision upon.
Can this board could this board come back to the 1,000-foot issue, or not after the court has made their?
You can't change the code. That's the reason that a conditional use is required. Whether to grant or deny the conditional use is what is the issue here.
If I may, the 1,000-foot requirement and the method of measurement, none of that is in dispute in this case. There is a place of worship directly next door. The only testimony on this regarding that method of measurement was from the school board's attorney that was questioning, because there is a middle school directly across 9 Mile Road. However, our method of measurement, you would have had to go to either intersection down 9 Mile to find a method of crossing 9 Mile. So the 1,000-foot was not an issue at all in this case. It's just the standard of, is there a place of worship within 1,000 feet, and no one is disputing that.
Thank you.
And if I may, case law establishes that when a case is remanded in this posture, we're back before you as though you had not taken that last vote. So we're back before you with, again, the evidence and testimony you had at your last hearing as though you heard it today, and asking you to approve in line with the court's order.
Well, but the court may not substitute its judgment for yours. The court may only quash and remand for further proceedings. So that's where we are. And yes, that is true. It's now back before you as though that vote had not occurred.
Thank you.
I want to be sure I understand. is it correct then that the only alcohol will be served indoors in a restaurant setting, that there will be no outside consumption of alcohol at the premises, and that there will be no package carry-out sales conducted? Is that right?
Correct. This is strictly for indoor, on-premise consumption. No outdoor consumption, no outside consumption or off-site consumption. So strictly indoor, on-premise at the restaurant.
And no drive-through or any type of other sales except that connected with the restaurant business itself?
That's correct. No drive-through is proposed.
Okay.
So, I'm still having issues. So the staff recommends that the board approve this conditional use because it meets all the criteria?
Correct.
Even though it doesn't meet the 1,000-foot criteria?
So the 1,000-foot, it's not a prohibition, okay?
Okay.
The 1,000-foot in this case is an identifier. The 1,000-foot measurement tells us in this case, if there is a place of worship or a daycare within 1,000 feet, you have to get conditional use approval. It doesn't prohibit it, it just says if something falls within that measurement, it has to come to the Board of Adjustment.
Along with the conflicting uses being visible to each other.
Yes, exactly the criteria. It needs to come to this board to be reviewed according to the criteria, not opinions.
And okay, so that's A. And the other criteria are met according to the staff's findings.
That is correct.
And that's why that's why the staff has recommended approval, because it meets the rest of the criteria.
That is correct.
Okay.
I have a question, Drew. Let's say for the sake of argument that we approve this. And time passes on. Would it be possible, and the alcohol consumption is limited strictly to indoors in a restaurant setting, and as I said, time passes on, could the applicant then come back and want to have outdoor service or have a package store or a drive-through? Could that be done if, again, assuming for the sake of argument that we grant this application?
The state of Florida has multiple types of alcohol licenses. The restaurant license that they're seeking is very specific. And when someone comes to us for zoning sign-off for one of those licenses, it specifically mentions any outside areas, and would outside serving be part of that license. If the board were to go in that direction, I would ask that the motion include any limitations like that, that then could be tied to that license. And in the future, if someone wanted to come in for a different type of license, they'd have to start over from scratch.
Okay, thank you.
We have, thank you. We have speakers. Speakers, please, are limited to 3 minutes. And as I call your name, if you will come forward to the microphone and state your name and address and be sworn in. Clay Mather.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name and address.
My name is Clay Mather from 8700 Klondike Road, Pensacola, Florida 32526. Hello, everyone. Thank y'all for having me here to be able to listen to me. So I own the property directly adjacent east of the proposed site here. I own the mobile home park there. Now, that we have looked at was, when you pull up the map, it does show commercial because it is a registered mobile home park, but it's still residential. There is a lot of children that live here, and there is a bus stop for these children less than 100 feet from this property. So I'm not against businesses, restaurants, anything like that. I think it's wonderful, and they should be able to do what they want to do. This particular area that we're talking about with the churches, the middle school. In fact, the last time we did this when I was here, we even had I believe an administrator from the Beulah Middle School that was here as well, explaining their concern. Same with me. With the bus stop, the children, there's over a dozen children in this mobile home park. Many homes are within 150 feet of this property. And I'm not saying that you can't say, well, they shouldn't be there at 10 o'clock, 10:30, 11 o'clock closing, because if a restaurant wants to do that, that's fine. But mixed with alcohol, I'm not sure if that's a good idea or not. I do feel like that if people want to have businesses with alcohol wherever, that's fine. But there's just a lot going on in this little area due to the exponential growth in the Beulah community. Coupled with the churches, the children, and the middle school across the street, I just don't think this particular location should be considered for alcohol, especially going late into the evening like that. And
Thank you, sir.
about
Board members, any questions of the speaker? We thank you very much, sir.
Thank you.
Richard Mills.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, God.
My name is Richard Mills. My address is 2480 Interstate Circle, 32526. And I'm here in strong opposition to the exception that's being requested for a variety of different reasons. One being the church that I attend is adjoining this property, and I personally don't believe there's any effective way to buffer that property from the church property. And the property in question, where they're wanting to put this so-called restaurant, is so small that there will be virtually no parking space when this strip mall is built, which is already in the works. If there's no parking space available there on that property, as I believe there's very limited parking space, it is to be expected that the patrons of that restaurant, sports bar, will be easing over onto the church property for parking spaces. And that will be very detrimental to our operation of having a church there if people are parking there for that purpose. And it's very clear, as Mr. Mather pointed out, there's a residence directly east of the property. There are the two churches that have already been mentioned. There is another residence within 1,000 feet west of that property, which also would be impacted by the exceptions that are requested. And it just seems like this is just altogether a bad idea from any viewpoint that can be considered. Thank you.
Thank you, sir. Any questions of the speaker? Thank you. Mac Davis.
It's Mark Davis, M-A-R-K.
Sorry.
That's okay, not a problem. Mr. Smith.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Go ahead.
My name is Mark Davis. I live at 2931 Angus Circle in Molino, Florida. I'm the pastor of Christ Community Baptist Church, which our property is 0 feet between the property in question and our property. And all due respect to the staff, the pictures that you're seeing up here are not the correct pictures. The property's already been cleared, all the vegetation is gone, and so there are no buffers on that side of the property for us. According to the code that you have before you as well, I'm sure, Section 6-34, there are three different types of businesses or places that are under your purview here. First, places of worship, dwellings, and schools. On the west side, 0 distance between the two properties for a place of worship. And then a little bit further down on 9 Mile Road, there's another place of worship. On the east side, there's 0 distance between the place of worship, a place of business that you're determining about today, and the dwellings. And so you're violating the code. And I realize that you're looking for expert witnesses. This is about as expert as you're going to get. Take a ruler out there, and you're going to find it's 0 between these places. And so now if you decide that it's okay for a business that sells alcohol to be next door, our young people, our children are going to be exposed to that. As it's already been mentioned a moment ago, it's a piece of property that's not even a full acre. And when people come to visit there and to do their business, they're going to need additional parking. If this business does real well, they're going to want to park on our property. And the answer is no. We'll be towing cars daily, I'm afraid. Not only do I tell you this, but in the Bible itself, it speaks clearly against this. And we hold to the Word of God. It is our doctrinal stand to resist alcohol. And so by saying yes and putting a place of business there that's going to sell that, it violates the Word of God. I can give you references if you're really interested. I can read it to you today if you're interested to put into record that the Bible speaks clearly about the consumption of wine and alcoholic beverages. And so as the pastor of the church, I do stand in opposition. I realize the court made a decision because no expert witnesses. And if you look on my form, I did mark that I am an expert witness. I can tell you exactly what the Word of God says and the reason for the opposition that we handle today. So I encourage you to stand up on the ethics of the Word of God and also to stand on the very ordinance that Escambia County has decided that this is the way that we're going to do business in our county. I will add very candidly, making the decision to allow this today opens the door for this to be in all Escambia County. And so you're setting a precedence for this county. And to be able to say yes here, you'll not be able to say no to any other alcohol serving business in the future. And that is going to violate a lot of churches in our area. Thank you.
Thank you, sir. Any questions of the speaker, board? That's good. Thank you, sir.
Okay.
Eric Mills.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
My name is Eric Mills. I reside at 357 Fargo Road. I am here as a representative of Christ Community Baptist Church. It was what I understood to be fairly clear that the section that was quoted to you a minute ago, 6.34, says that you're not supposed to be able to put alcohol consumption next to a church. Apparently, I wasn't the only one confused. There's obviously some loopholes and some adjustments that are trying to be made here. Y'all were clear on it the last time you voted. It's not right to put it next to us. I hope that you'll stand, show some integrity today, vote the same way you did last time when you looked at the county ordinance that says, don't put it next to dwellings, don't put it next to churches. It's wrong, and there's a reason for it. Thank you very much.
Thank you, sir. Any questions of the speaker? Seeing none. John Pavlis.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
John Pavlis, 1417 Moonlight Drive, Cantonment 32533. I just want to ask the board to look past today. You're setting a precedence. A precedence is not a good one. I don't know where it will stop. A slippery slope. Also think about the people who are already there. The church, the mobile homes, what it's going to do to them. It'll be a negative impact on them. People will not want to live next to a restaurant such as this one. So the mobile home owner's going to suffer. People may move. He may not be able to rent out or sell his mobile homes. Churches, people will not want to go to that particular church, so that church will suffer in attendance and other ways. Also, the church has children. They have activities during the day other than Sunday. Also, activities in the evening. Think about not just the restaurant. Think about the people who are already there. The negative impact it will have on them. There's a lot of land and space in Escambia County where this restaurant could open up with no problem. No hearing, no waiver, but they choose to go between a church and a mobile home park. That's just not the best place to be. I would ask you to rely heavily on the ordinance. What do we have ordinances for? Why do we have laws? If I don't like a law, can I just change it? I ask this board to enforce the law, the ordinance. If this owner of the restaurant wants to change the ordinance, let them go through that process and change the ordinance. But they shouldn't be allowed to open up a place that serves alcohol consumption with 0 feet between a church and a residential area. Thank you very much.
Thank you, sir. Any questions of the speaker? Thank you, sir. Deborah Mabick.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
My name is Deborah Mabry. I'm a member of Christ Community Baptist Church, but I also understand the need for codes, code enforcement, zoning, and ordinances. And there is an ordinance that has been in place for a number of, for as far back as I can remember, 6-34, that says no permit will be given to any restaurant, any business that sells alcohol in within 1,000 foot of a place of worship, residences which are around there, and there's also a middle school. So I implore you to uphold the ordinance that's already in place, and that you will not permit a loophole or a way out so that other things. It will cause a trickle-down effect to the rest of the community. So for the safety and protection of our community, I implore you to uphold the ordinance that's already in place. Thank you.
Thank you very much. Board, any questions of the speaker? Seeing none. Allison Mather? What's she-
She wishes not to speak.
Doesn't want to speak?
Correct.
Okay. Mark Gibson.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
Good morning. I'm Mark Gibson with the First Church of Christ Scientist, which is the second church within the proposed conditional use area. I'm going to read this letter that I wrote, and then I will present it to you. Board of Adjustments, on behalf of our church membership, the Board of Directors, First Church of Christ Scientist, Pensacola, does hereby unanimously object to the conditional use proposed by the subject case number. We are solidly in support of the Land Development Code, which prohibits the proposed use when the vicinity of a church is encroached. Not only is the use within the prohibited zone of two churches, but is also in close proximity, as we've said, to a middle school and residential areas. This is our second objection to this proposed conditional use in the past 14 months. The Christian Science Church has been in downtown Pensacola for 60 years, and then we were on 9th Avenue for 50 years. We bought this property 6 years ago, and built our new church. And one of the main reasons was of its location would be there was no alcohol around that location. There was a middle school, there were residential areas, and a place where we could be free from the constant things like this that we faced on 9th Avenue. And now cannabis places, we thought, well, now this will be free from those type things. And now this has come up, and I will just reiterate that we are in support of the Land Development Code, and we hope that it is upheld in this case. Thank you.
Any questions of the speaker? Thank you, sir.
Thank you.
Is that the first time, staff? We need a motion on that?
If this is an updated letter from the last one, yes, because it's not the exact same, you would need a motion if you were to accept the letter into evidence.
We seek a motion to, we have a motion.
Mr. Chairman, I'll move that we accept the letter.
Thank you, sir.
I second. Second.
We have a second, motion and a second. Those in favor, raise your right hand. Passes unanimously. Paul Stahl.
He wishes not to speak, Chairman.
Do not speak, I'm sorry. And duly noticed, Amanda Paulus does not wish to speak, but is opposed to the effort. Is there anyone who filled out a blue card and didn't get to speak? Would the staff make a final statement, would you like, sir?
Yes, sir. The county staff and you as the Board of Adjustment are limited to discussions and decisions based on the Land Development Code. Much mention has been made of Section 3.6-34 from the County Code of Ordinances, which is outside this staff and outside this board's purview. That section of the Code of Ordinances deals with bottle clubs, which is a different use, completely different license type. And again, outside this staff and this board's purview, you are strictly here to deal with the Land Development Code, and that's what's been addressed here. That is in section 4-7.5 of the Land Development Code. The conditional use is set forth in that. There are some uses where alcohol consumption would be completely prohibited. That would be in the case of a school. For churches and daycares, there is the conditional use option. That is what the applicant is seeking, and that section of the Land Development Code is the only thing that your staff can address, not other sections of the code of ordinances. In addition, when neighbors come to speak before the board, they don't do this all the time, okay? For a lot of folks, it may be the only time they're going to come and speak before a board in one of these quasi-judicial proceedings. This board gives folks a lot of leeway, which in many cases, I think that's completely appropriate. I would just remind you of what the court has said regarding speculation and testimony regarding possibilities. Well, it could be this, it could be that, and it violates something you're not even allowed to address. That was all factored into the court quashing your earlier ruling. I would just remind you of that. We're dealing with a very narrow scope here.
Thank you, sir. Board members, any questions of staff? Would the applicant like to make a summary statement?
I would, yes, thank you. I appreciate your time this morning and your time when we were here over a year ago. A lot of what you heard today echoes what was presented back in January of 2022. And it's no more competent and substantial evidence today than it was then. As to the mobile home park, the court's ruling specifically addresses that on page 5 and notes that it's completely irrelevant that this is next to a mobile home park. LDMU zoning allows for restaurants to serve alcohol. The only reason we're here is because of that 1,000-foot of the church. You know, the idea that the Bible or some religious text prohibits or, you know, frowns upon alcohol service is not one of the criteria in the code. And, you know, I would argue that there are plenty of people who, you know, find themselves Christian or follow the tenets of that book, who believe in drinking alcohol. That's an opinion. It's outside the scope of what this board is to consider. You know, I agree with the residents that you should adhere to the code, but as Mr. Homer stated, the Land Development Code is very clear that if you meet these criteria, then you're entitled to conditional use approval. And we have met the criteria in the code. And, you know, Florida is a private property rights state. Your own comprehensive plan has a private property rights element, and the property owner has a right to develop and use their property in a way allowed by code if they've met the criteria. Staff again today has presented their expert testimony, gone through the criteria, opined that we have met the criteria, and recommended approval of the conditional use. So we would ask that you approve the conditional use. Again, the fact that there are dwellings nearby is not relevant. The idea that this may morph into something or set a precedent down the road is not relevant. The only thing relevant before you today is, have we met those criteria outlined in the code that are required before we can serve alcohol within 1,000 feet of a church. I say we have, your staff says that we have, and so I'm simply asking that you follow the edict of the court. Find that the other testimony presented here today, while it may be moving, it may be emotional, it may be interesting, it's not evidence sufficient to overcome the findings of staff that we've met the criteria in the code. And so it may be a hard decision to tell the neighbors that what they say is not a criteria in the code, but the code mandates that you tell them that that's not a criteria and that you grant the conditional use approval. And the court has said the exact same thing. So I would just ask that you follow what the court has said.
Thank you. Board members, any questions of the applicant? The chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. Do we have a motion?
I'll try this one. I move that we accept conditional use of this property and accept staff's finding with respect to the application, and request that staff work with the applicant to develop visual barriers on the perimeter of the property to the point that visual sight is controlled.
We have a motion. Do we have a second?
Could I ask you to quantify that? Such as
The barrier.
You want it more concise?
A specific, please, I need
Okay.
something
Sure.
concrete.
Hold up on the second till Marty gets his motion.
The barrier would be on the perimeter of the property and would eliminate all visual views across the property.
A privacy fence?
Pardon?
Could you maybe say, an 8-foot privacy fence or something like that? Where allowed by code? Please.
Yes, an 8-foot fence were allowed by law, and plantings appropriate for the area.
Thank you.
I'll second it for discussion with a proviso that the motion also include prohibition against all other types of alcohol sales except those that have been presented by the applicant as indoor connected to the restaurant business.
I would accept that change to my motion.
Thank you.
The license as requested, then?
Yes.
Yes, okay.
Okay, we have a motion by Marty.
Before we do any vote, can I ask to see the layout? I want to see
Site plan.
what is the distance. Okay, it's 165 feet on the front boundary line. Would it be advisable to, regarding the buffer, put some, so many feet of buffer or so many, is that something that would be better for the review process.
So on the plan, they're proposing a 12-foot landscape buffer, which obviously would be, by this motion, supplemented with an 8-foot privacy fence on all three sides. Obviously, not along the right-of-way. But then that buffer, once again, would be 12 feet as proposed.
Also, I would like for the motion to be clear that the vegetation should include trees and bushes.
Yes, sir. These buffers include for different heights, from shrubs up to trees in each buffer, to provide for a more comprehensive planting schedule.
Is that clear enough on your motion, Marty?
Yes.
All right, any discussion? We have a motion, we have a second by Michael Godwin. And time for discussion. Is there any discussion?
Mr. Chairman, this is a difficult vote. I mean, I think the court has pretty much indicated where we are on this. But as I said, it's just a difficult vote, and I honestly don't know any other way to go except going ahead and approving this, I guess.
I agree. As far as the courts has pretty much made a decision, my decision still stands the same. But it seems like, kind of being bullied into a decision, That's what it feels like. But I still stand the same on my decision.
I'll have to add to that and say that this is one of the gentlemen in the audience had stated this does set a precedence, and it's a very concerning one. I hope that it's something that the staff and the county will look to in the future, changing the way our hands are bound on this type of situation. And it will definitely should in the future something like this come before us, and it has in the past, and we voted against it in the past. Have to take another look at how we are held by the existing code in determining.
And Mr. Chairman, also how the staff evaluates these kind of issues. We have a situation where we have two churches, a school, and a mobile home park, all clustered basically together. And I understand, and the lawyer in me knows, that you have to have competent and substantial evidence to support your findings and your decision. So I understand that part. But I would implore the staff to, when evaluating these, to take just an intensive look at these issues. I mean, I honestly don't know how the staff opinion arrived at the opinion that it did. But I know our staff, I trust them. They're all highly skilled professionals, and I know they do their best to do their duty. So that's not any knock on them. But I honestly can't see how we got to this decision. I really can't. But we are there, and it is what it is, as the saying goes. So I think we know what we have to do, Mr. Chairman.
We're going to now call for a vote, and just to repeat, it's a request for conditional use to allow alcohol consumption on premise within 1,000 feet of a place of worship. That is, that's what we're voting on. And the motion is to approve it. Those in favor signify by raising your right hand. Okay, it's basically 3-3. Let's discuss it a minute.
Mr. Chairman, the proposition would fail if it's 3-3, I would believe.
True. Any questions, any further discussion? So, should we reconsider since it's a tie?
I would ask that you do reconsider, with the understanding that the court has been very clear with the instruction that you look to the criteria outlined in the code and the expert testimony presented. And, you know, while you may be voting based on emotion or on a feeling that you wish the code were different, I would just ask that, you know, you give the applicant the consideration that they've gone through this process, they've been to circuit court, they, you know, labored a year in court to come back before you today on the same facts, the same findings that the court has already ruled on, and that you take that into consideration. And I would ask that you reconsider and vote in favor of approving the conditional use.
Mr. Chairman, maybe perhaps our attorney could advise us on, in a situation like this, what are our avenues?
I can't advise you as to how you should vote. However, I can at least advise you that it's unlikely that a denial of the conditional use would be upheld were it appealed again. So please
Procedurally, where do
consider-
we go from here?
Please consider
procedurally.
the evidence that has been presented. Please consider the court's ruling and and only you can make the decision. If it's a tie vote, then the motion fails. Procedurally, someone can propose another motion.
Mr. Chairman, I would make the same motion again, perhaps a little clearer with respect to buffering, but it makes no sense to me to make the same motion again. Perhaps if a different motion is made, it would be worthwhile voting again.
I don't know if this is gonna help or hurt the situation, but if this does go back before the judge, with all due respect, I disagree with what she said. I don't think that she understands or is in my mind as to why I did or didn't vote for this issue. So I guess I will put it on the record so that she does know. I disagree with with the staff's findings based on criteria D, nuisance and hazards. It clearly states hazards for adjoining properties and other properties in the immediate area. There's 2 churches and a school, middle school, I believe. Consumption would be during school hours. I know the school is not within 1,000 feet based on how we measure. However, it's across the street. It's closer than, as the crow flies, than many of the other issues that have come before us that we've denied. The restaurant, whatever it is, sports bar, I don't know what it is. It's a restaurant that serves alcohol. There is a potential, and I say potential because of the layout that's been given to us that clearly states that there's 2 buildings. So it's not a potential. It's presented to us as 2 buildings. And one of the buildings is a retail store. We don't know what the retail store is, so we don't know. According to this, it's 4,275 square feet. My understanding is that's an additional 13 spaces. I also, since if the judge is going to be hearing this, believe that it also doesn't meet criterion H, which is site characteristics, which deals with size, shape, location, and topography of the site. I believe that with the amount of buffering, the additional building that's coming up in the future, and once again, that's not projection, it is based on Helen Simpson's letter. There's no date on this, but it says we are preparing to submit for a conditional use for the proposed 9,000 square feet. So that's another conditional use coming before us. So now we're talking about size characteristics, which leads me to believe that this location cannot accommodate for buffering, for adequate parking, so there's no spillage because of the over 9,000 square foot buildings that will be placed on the property. And that's probably rambling, but at least the judge will know where my mind is. That's all I gotta say.
Do you want to put that in the form of a motion?
Okay, I move to deny staff's recommendation and not approve the conditional use based on criteria D, nuisance and hazards, based on the fact, the evidential fact that there are 2 churches and a middle school in close proximity that this restaurant will be opened serving alcohol during school hours, during the children getting out of school, and criteria H, size characteristics, because of the applicant stating that there's going to be 2 buildings, one a retail, one a restaurant, coming up to us for a conditional use for the proposed 9,000 square feet. To include that other building, which we do not know at this time what it is, but the size characteristics of the property, I believe, will not fit both the restaurant, the adequate parking for the restaurant, the buffering, and an additional 4,275 square foot retail facility. Is that appropriate?
Okay, we have a motion. Do we have a second?
Second.
We have a second by Willie Kirkland. All those in favor signify by raising your right hand.
Mr. Chairman, before we vote,
Oh, I'm sorry.
I'd like for the record to be clear that the basis of the motion are the documents that have been placed already in evidence and accepted as a part of the file. And that these are now on record. Mr. Chairman, I think it's important that we make that clear, that the basis of the objection, and from what I understood it to be, it was based upon documents that we have and have accepted into evidence. The only other thing is, just as I remarked before, I really don't understand how the staff was able to come to its conclusion, but that's neither here nor there, and as I said, I know they acted in good faith, and I respect their work and their opinion, but I just don't believe that the location was taken into account. But I did want to get that on the record.
Thank you.
And I will concur, as I was the one that made the motion, that is correct. This is based on the factual evidence presented to me by the staff. And as I stated in the motion, based on the layout, the information provided by the applicant, that I'm basing my motion.
Thank you. Any further comments or discussion?
And just to be clear, in that motion, y'all gotta excuse my chair. Just to be clear, in that motion, when you say school hours, that's including the daycare hours as well at the churches, right, for the kids?
Yes, that is correct.
And also, Mr. Chairman, I know, and our attorney has advised us that we have to be careful about lay testimony that are not experts. But if I understood her admonition, she did say that facts, lay witnesses can provide facts, if I understood her correctly. And I've listened to the testimony of the witnesses. I will remark that I think the record, to me, should show that as to the testimony regarding the mobile home park, that there was, in my opinion, a good deal of it was factual concerning its location. I think that's a fact. That it has elderly people and children. I believe that the owner of the mobile home park surely would know factually what kinds of individuals he has in his business, his mobile home park. So I think items, and that it is located right next to this proposed development. I think that those kind of items, I would think are testimony from a fact witness. I discounted the opinions. I tried my best in his testimony to discount any opinions about the effects and all that sort of thing. But I believe that for that particular witness, based upon what the motion, the new proposed motion is, it complements and is additional evidence supporting the proposed motion.
Thank you. Any other comments? We have a motion by Jennifer, a second by Willie. Those in favor of the motion signify by raising your right hand. 5, 1 negative. So the conditional use fails.
Mr. Chairman, could we take 5 minutes?
Yes,
We've been
sir.
going at it
Yes,
for
sir.
a while.
Or closer to 10. I need to change out some planners and rearrange some things if you don't mind. A 10-minute break. Yes, thank you.
Yeah, God, and I know she's going to, I call my daughter, I will call my daughter, wake her up, and go downstairs.
I think we're about ready, y'all. We will now re-begin, and we remain with a quorum, 6 members present. Next case we're going to address is conditional use 2023-03. Board members, has there been any ex parte communication regarding this case? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself at this time, state your name and address for the record, and be sworn in by the clerk.
Good morning. My name is Carly Hansen. I live at 13810 Blue Springs Road in Youngstown, Florida, 32466.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Were you given a copy of staff's findings of facts?
Yes.
And would you like to summarize them or make any comments at this time?
Yes. Good morning, Mr. and Board. My name is Carly Hansen, and I am a professional planner working for the Planning Collaborative to represent the applicant of the item today. We are requesting a conditional use approval to build a structure larger than 6,000 square feet in the high-density mixed-use zoning category. As this property is within the mixed-use urban future land use category, both the future land use and the zoning designation allow for a retail store. However, due to the size limitation placed on retail stores within this zoning district, this conditional use is sought only to increase the square footage allowance. The applicant is proposing the construction of a retail store, approximately 10,640 square feet on a 1.66 acre parcel located at 1405 Gulf Beach Highway. We agree with staff's findings and agree that the application meets the criteria for the conditional use request and concur with their recommendation for approval. We'd like to emphasize that there is an existing use currently on the property. The property appraiser of Escambia County says that there's 17,000 square feet of structure already on the property. So this new development will be constructed at a considerably smaller use. That new use will also improve stormwater and safety with regards to ingress and egress of the property. Thank you.
And what's the name of the business?
It's a Dollar General.
Dollar General?
Yes.
Board members, questions of the applicant? Seeing none, we'll address staff and might get back with you in just a sec.
Thank you.
Staff's findings?
And Kim Wilson, she was not here earlier when I swore in staff. I'm going to go ahead and do that now. Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
So this is CU 2023-03. Conditional use, excuse me. I sure will. I'm sorry. This is the location map. This is the radius zoning map showing the current zoning of the parcel. This is the future land use map showing mixed-use urban. And it also falls within the CRA overlay district, which is Warrington overlay. It does fall in the airport environment protected zone, AIPD 2. This is an aerial map showing the building, the parcel off of Gulf Beach Highway, or fronting Gulf Beach Highway. That's the public hearing sign, public hearing sign. That's looking north from the site across Gulf Beach Highway. That's looking directly at the site, south on Gulf Beach Highway at the building that's already there, the existing commercial building. And that's also looking south onto that building across Gulf Beach Highway. That's looking along Mills Avenue, south on Mills Avenue. And that's looking west down Gulf Beach Highway from the site. And that's looking east off of Gulf Beach Highway. And that's it for the pictures. So the applicant, like she stated, is seeking conditional use for a building greater than 6,000 square feet. Criterion A, the findings for that, if you don't mind, I'll go straight to the findings. The proposed use is for retail business, and it is compatible with the adjacent properties and other properties in the immediate area. It's approximately about 770 feet along Gulf Beach Highway. They're commercial businesses, and there appears to be an existing residential and commercial uses abutting the site property as well. A retail use would be compatible with the surrounding uses in the area. Criterion B, facilities and services. The applicant indicates that they will utilize the existing sewer and water services that they already have on site. If facilities are required and services are required, that'll be evaluated during the site plan review process. Criterion C, on-site circulation. Ingress to and egress from the site and its structures appear to be sufficient. The property has frontage along Gulf Beach Highway and Mills Avenue. A preliminary site layout was provided by the applicant. Required on-site circulation will be further evaluated during the site plan review process as well to ensure all the requirements and regulations are met per the LDC. Criterion D, nuisances and hazards. The proposed use should not generate unreasonable noise, nuisances, or hazards for adjoining properties and other properties in the immediate area. Criterion E, solid waste. All on solid waste facilities, solid waste containers will be appropriately located for functional access, limited off-site visibility, and minimal odor and other nuisance impacts as required by the LDC. And that will also be further evaluated at the site plan review process. Criterion F, screening and buffering. Screening and buffering will be evaluated during the site plan review process per the LDC. Neighborhood commercial uses consist with the mixed-use zoning district and other non-residential uses not otherwise required to provide more substantial buffering, are to provide a 12-foot vegetative buffer supplemented with an opaque fence or wall. It is in that overlay district. Criterion G, signs and lighting. Signs and lighting will be limited to what is allowed by the LDC, and that will also be reviewed, of course, during the site plan review process. Exterior lighting is to be installed not to shine directly on adjacent properties. Signs and lighting requirements will also be evaluated during the review process. Criterion H, site characteristics. Based on the site plan that they submitted with the application, the size, shape, and location of the parcel will accommodate the proposed structure. The property is approximately 1.66 plus acres. The preliminary drawing indicates the building location and associated parking appears to be adequate. All requirements must meet the LDC upon site plan review process. Criterion I, use requirements. This project does not have any conditional use requirements, and all other code requirements will be addressed during site plan review process. If the conditional use is approved, the applicant will submit plans that must meet all standards per the LDC, as well as the Florida Building Code during construction. Staff finds that the applicant can address the conditional use criteria that would allow for the retail store in the HDMU zoning district. and therefore recommends approval pending completion and adherence to all requirements of the site plan review process per Land Development Code of Escambia County. Staff concludes.
Thank you.
Thank you.
Any questions, board members of staff?
Would you pull up the site plan, please? Do you know if any of the existing buildings will be left on place, or are they all being removed?
I believe it's being demoed, all of it, is it not? That'd be a question for the applicant.
Yes, the plan of the development is to remove all 3 structures currently existing on the property.
And the 17,000 square feet that you mentioned was a combination of all of the existing structures?
Correct, yes. The largest, I believe, is around 12,000 square feet.
I have a question, Mr. Chairman. What about the overlay district? Is that compatible with this?
It falls within the Warrington Overlay District. I'm sorry. It falls within the Warrington Overlay District. They will have some requirements as far as that with CRA. And I do not believe anyone is here from CRA representing the CRA department.
Usually they submit a letter.
Not for conditional use. It would be during the development review process. They'll submit their requirements.
What about the neighborhoods surrounding it? This proposed development essentially is going to fit into the footprint of what's existing now, is that right?
Correct.
Therefore, the things would remain essentially status quo as far as the neighborhoods, I'm presuming then?
Correct.
On this drawing, what is that 12-foot gap in the middle? Or 10-foot?
So,
What is that?
You okay?
Existing 10-foot right-of-way to be vacated.
That is correct. That, there is a portion of right-of-way. This is, these properties are all from an extremely old plat. That is in process through our real estate department to get that vacated, which would have to happen prior to the issuance of a development order.
How far, just as a matter of interest, I guess, how far is this from the intersection of Navy Boulevard and?
Give me a second.
It's not.
Yeah.
If it's a mile. 0.9. Yeah, 0.9, okay.
Is the property vacant?
No, as you can pull the aerial back up, or that picture, it has an existing buildings on the lot.
I mean,
As she
is it
stated.
vacant as businesses active in it?
It was operating as a lawn and garden center, and they recently closed in January of 2023.
Okay.
It's approximately 3/4 of a mile from the intersection with Navy. And So this has been through for a pre-application with development review. It was identified as being in a CRA area, and have been asked by our staff to provide comments, and as part of that development review process.
Mr. Chairman, this is the kind of development I have traveled this stretch along Gulf Beach Highway. It's sorely needed to have some commercial development there, it would seem to me, and or redevelopment, I guess, in this case. And I think this would appear to be helpful to that area.
Let's get the speakers and then we'll do a summary. Drake Dimitri.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name and address.
Drake Dimitri, operating a business at 1529 Gulf Beach Highway, residence at 208 Berry Road, 32507. I've been operating my aluminum product manufacturing business 2 doors down from there since 1998 at that location. And I do desire good economic development in the area. In general, I would say there's not a very good overarching economic development plan, and I do follow, the tenets of a free market, but I think this is not the kind of quality that we need there, and there's some infrastructure issues and qualitative issues. First of all, the status quo is lagging. The road needs to be developed. You're going to encounter some traffic issues with the presumably high rate of ingress and egress. There's a stormwater issue. There's really no proper stormwater evacuation plan, and it's basically a floodplain, I believe. I'm not aware exactly what the LDC is about, but I would just take this point in time to lament the fact that I don't think there is a proper economic development plan for the area. And I repeatedly, we ship products and we receive trucks on an almost daily basis, and I get a complaint from most, and sometimes it's almost all drivers, of the severe difficulty they have in ingressing and egressing to our facility, which is right on the corner there of Wayne and Gulf Beach. So I think there needs to be some communication with the DOT on how this area should be developed. There's no traffic lights there, although I've heard recent thoughts that they were proposed on Mills and also Patent and Sunset. But the big elephant in the room is there is a dollar store less than about 1,000 feet away, just north of Sunset already. So.
Okay, thank you. Tony Gillette.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. State your name and address first.
I'm Tony Gillette. I live at 625 West Sunset Avenue. I'm just an ordinary guy. I really wasn't sure exactly what was going on here today, so I figured I'd show up and, try to see what was going on, if my property was threatened, if it was, what was going to be built here, and just try to find out what's going on. I'm not sure exactly which side of the road that's on, if it's on the side where the electric company is, or actually it's the water company, I'm sorry, or if it's the other side, but there is a Family Dollar located in that area, and a Family Dollar already down the street. We just recently had, I think, 4 people die in a car accident on my street, on the corner of Sunset Avenue and Gulf Beach Highway. So there does need to be some consideration there as far as traffic, some kind of traffic signals or something. It's very dangerous when you try to pull onto that street. So with an added business, it's going to create more traffic. These are just considerations that I have. The main one I had, I really, I'm not even concerned with anymore. I thought they were going to try to expand back a parking lot or something, but I guess not. So that's it.
Thank you, sir.
Thank you.
We note you did not desire to speak, but you're on record. That is Luke Strickland, I believe.
Hey, yeah, thank you very much. I work for the developer. One thing I did want to address regarding the last couple comments. Sorry.
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
915 Pine Street, Tallahassee, Florida. Luke Strickland. Going back to address a couple of the concerns of the last 2 comments, DOT actually does have road expansion plans for that area. I believe they're on the shelf right now, but they'll be taking a small portion of frontage to Gulf Beach Highway. I'm sure they're considering traffic lights and that sort of thing, but there are ongoing road plans for this area that should address some of the concerns, I would imagine. That's all I really have.
Thank you, sir.
Thank you.
Alan Mills Gunther does not wish to speak. Is that still the case?
That's me, just in case you have any questions.
Thank you. Board members, discussion with,
I have a couple of questions for county. I think the question was asked, but I didn't hear an answer. Regarding the aerial map, that section right through the middle there that doesn't appear to be part of the property, is that an easement?
No, sir. What that is part of an alleyway that was part of that original plat in that area. It has been since discovered that it was never vacated, and they are in the process of getting that vacated through the county.
Okay, great. Thank you. Second question. I think I saw on the site plan septic field. This property is not serviced by sewer? Is that correct?
I can pull that up on the comments from ECUA as part of the development review. Let me see real quick. ECUA. It said the project area is served by Peoples Water Service Company for potable water. Peoples is actually what one of the speakers was referring to as Catty Corner across to the north. Project narrative proposes use of septic tank. There are no proposed connections to ECUA system, therefore no comment from ECUA engineering at this time. Now that was from the pre-application, which is a general overview, hey, here's an idea of what we want to do. It doesn't have all those exact engineered specifications. But I don't see anything in that comment from ECUA that would be requiring them to connect to sewer at this time.
Is there an ECUA main available? Surely there must be running along Golden Beach Highway.
Yes, sir. I believe there is, outside my knowledge base, but I could look that up for you. I believe there is.
Well, Mr. Chairman, this is I think, a fairly important issue.
Okay.
I thought it was the policy of the county and ECUA to get away from septic tanks, especially for commercial development.
Since the time of the pre-application, this letter that is on the screen now was received. And it said, to whom it may concern, this confirms that ECUA provides sanitation only at that location. It's not saying that they're going to be required. I thought they would be. That would be a question for ECUA. Again, People's Water Company is the potable water supplier. Should they connect to ECU to sanitary sewer, it would be under ECUA.
I'd like to hear from the applicant on this, Mr. Chairman.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
For the record, my name is Alara Mills Gutcher. I'm a certified land use planner. So the question is whether or not we'll be connecting to a main line, and absolutely, if there's one available to us, we will. All of this was still conceptual at the time of this application, so certainly we will if it's available.
So you will be.
If it's available.
If it's available,
That's
you will
right.
be connecting with the sewer system. Okay.
Certainly.
Thank you.
Well, I have her still up there. Laura, if you would give us a summary of your compatibility analysis, please.
Certainly. And so I will summarize it to the best of my ability because Carly actually is the one who put that together for us today. Would you rather have her present that, or do you feel
Whoever.
comfortable presenting that? Because this was actually her case.
Okay.
Thank you. So with regards to compatibility, we did an analysis that included the county's comprehensive plan definition, land development code, and the state's requirements for compatibility. The Escambia County Land Development Regulations offers some guidance on rezonings. Some guidance on analyzing compatibility when a new use is introduced. However, we'd like to note that this is not a new retail use going in. There is an existing retail use there, or was previous as of January 2023. But for the purpose of satisfying this requirement, we looked at that a compatibility analysis regarding section 3-1.6. We found that there are existing non-residential and residential uses surrounding this site, and that the addition of this proposed development constitutes as infill. And if, in order to ensure compatibility with our site and the surrounding uses, we will be sure to include landscape, buffering, and screening as required by the Land Development Code. Is there any other specific questions I can go into?
No, I just wanted to kind of get an idea of what the surrounding site was like. I'm not familiar with the area, so.
Okay, so directly around the site, we looked at the adjacent properties. The subject property itself is designated by the Escambia County Property Appraisers as store, office, single family. On the corner across from Mills Avenue, there is a church. The owner of the subject property actually owns the next 3 properties down that are mobile homes, single family residential. And then catty corner across Gulf County to the West, there is a store, one story, which is an existing convenience store.
So it's my understanding, as I mentioned earlier, this project would essentially be a status quo kind of thing. It will not be disturbing the general area as far as the housing and other businesses. I mean, this is really just a replacement kind of thing. Is that right?
Correct. We like to reiterate that we agree with staff that this proposed use will not generate any unordinary noise, nuisance, or hazards to the adjoining properties or the properties within the immediate area.
I believe that's it. Thank you.
I do have an answer on your ECUA question. So there are main main gravity lines north side of Gulf Beach Highway. These are running down Lound Avenue and Mills Avenue to the north across Gulf Beach is the nearest point that they could connect. Also, I'm sorry I missed the first part of this. I was unavoidably pulled into another issue. Just as a basic reminder for everyone, this is a conditional use regarding the size of a retail operation. It's not about the type of store. It is in a CRA. It's in the it is in that Warrington CRA. The CRA does not prohibit this type of use. It would simply just provide some design standards, and that was part of CRA's comment during the pre-application.
Any questions, board, of staff, or anybody? Yes. Well, you've already spoken, you just have a question.
The microphone, please, if you would, sir. Thank you.
Was there any kind of study of any degree of the traffic impact of this? Because I would presume that dollar store type of traffic is going to be higher than the previous establishment. And I've seen ingress and egress accidents already around that area. Also, it was mentioned the CRA has prohibitions or whatnot. I was under the impression that the CRA had a prohibition or inhibition against the same type of convenience store located next to each other, and theirs is at 2,500 feet. I believe it's a lot less than that. And it's the next direct commercial establishment.
Correct. That deals with specific retail type uses. A proposed dollar store is not under that prohibition.
Okay, sir, thank you very much. Chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go over them and say why. Chair's ready for a motion.
I'll make a motion that we approve staff's findings. Let's see, hold on 1 minute. Yeah. I'll make a motion that the that the board approves the staff's findings of fact.
Second.
We have a motion, do we have a second?
Second. Second.
Thank you. Second by Willie. Motion by Jennifer, second by Willie. All those in favor, signify by raising your right hand. Passes unanimously.
Chairman, let me, Drew, did I need to say pending completion and adherence to all requirements of site plan review process, or, I mean, that's kind of a given, right?
It is a given, yes,
Okay.
ma'am.
All right, just,
Thank you.
Next item is conditional use 2023-04. Board members, has there been any ex parte communication regarding this item? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none, does any board member intend to refrain from voting due to a voting conflict of interest?
Chairman, I do, the company I work for was hired to do the boundary survey of this property recently.
Let the minutes reflect that Jennifer Bass is recusing herself from a vote on this item. We still have a quorum with 5 members present.
Ms. Bass, have you filled out your form?
I have.
Would you like to read that into the record?
I'm sorry?
Would you like to read your disclosure into the record?
Okay, I disclose that I work for Rebel Battle and Associates. I work as the bookkeeper, office manager for that company, which is a civil engineering and surveying firm. RBA performed a boundary and topo survey for the applicant prior to the BOA meeting in which the applicant requested a conditional use. Is that good?
Yes. So you will not be participating?
And I will
or
not be
voting?
participating or voting in this matter.
Would the individuals who are party to this item please come to the podium and identify yourselves? Please state your name and address and be sworn in.
Meredith Bush, attorney at Clark Partington, 125 East Intendencia, Pensacola, Florida, 32502. The owner applicant, John Trikowski, is also present.
Thank you. You were presented with the staff's findings.
Yes.
Would you like to just summarize and?
Sure, I'll be happy to walk through our application and staff's findings. So the approval of this request is necessary to allow for development of a bar and nightclub in the commercial zoning district and to allow for alcohol service located within 1,000 feet of a church. No other conditions are sought. As to criteria A, or number 1, the hours of operation for the establishment will be 5 p.m. until 2:30 a.m. on Tuesday through Saturday. It'll be closed on Sunday and Monday. There are several places of worship in the vicinity of the proposed use. The proposed use of on-premise alcohol consumption will be conducted indoors and is not visible to the places of worship in the area. The on-premise alcohol consumption is limited to inside of the building. No outside consumption is proposed. And a condition that will mitigate any incompatibility is that the use will be indoors. As to number 2, facilities and services. Facilities and services for the site are being developed. ECUA is the water service provider. The site is currently on septic. There are services to the site and provide adequate capacity for the proposed use. Potable water, septic, and solid waste disposal are all available to the site with adopted levels of service to allow for the proposed use. As for criteria C, ingress and egress to and from the site and its structures is currently sufficient. Access is available off of North Palafox Street and Highway 29 or Pensacola Boulevard. The applicant will submit any necessary FDOT driveway connection permit or safety upgrade permit as may be required. Parking will comply with county standards. The applicant will proceed with the development review committee process upon conditional use approval. As to nuisances and hazards, the proposed use will not generate unreasonable noise, glare, dust, smoke, odor, vibration, electrical interference, or other nuisances or hazards for adjoining properties and other properties in the immediate vicinity. As to solid waste services will be provided to the site. All on-site solid waste containers will be appropriately located and screened from off-site visibility. Screening and buffering, the appropriate landscape buffering will be provided. The applicant will comply with all county design standards. As to signs and lighting, all signs and lighting will comply with the county design standards and will be appropriately placed to avoid any nuisance impacts on the surrounding properties. Site characteristics, the characteristics of the site adequately accommodate the proposed use. And then use requirements, the property is within the commercial zoning district, which allows bars, nightclubs as a conditional use, including the on-premise consumption of alcoholic beverages. Staff, in their findings, agree that we have met those criteria as outlined in our application, and they have recommended approval. We concur with those, with their findings.
Thank you very much. Drew, do you have anything to add?
Yes, sir. I'll go through the staff's presentation. Here we have our location map. As you can see, the site is in between. It has frontage on two roads, Old Palafox, which is County Collector Road, and Highway 29, which is a federal major arterial roadway. The zoning on site is commercial. You can see in the surrounding area, you've got quite a bit of heavy commercial, light industrial. There is some high density mixed use off to the west across the highway. Future land use for the site is commercial. Commercial future land use allows for the zoning district of commercial and also for the surrounding heavy commercial light industrial zoning. Aerial map of the site, as you can see running down the middle, that is right of way that divides these two parcels. It's essentially unopened county right of way. It's opened, it's just not paved and maintained. This is the public hearing sign that was posted on Highway 29. This is looking northeast into the site. There's an existing building there. This is looking south along Highway 29. This is looking west into the site down that right-of-way. This is a public hearing sign that was posted on the northernmost parcel on Old Palafox. And this is the public hearing sign posted on the south parcel on Old Palafox. This is looking back west from Old Palafox down that right-of-way. Looking south on Old Palafox. Okay. As to the findings, so this is rather interesting in that the zoning district for a bar or nightclub requires conditional use approval. The county did identify that there is one place of worship within 1,000 feet, so this is covering both of those. At such time, should this be approved, when they come, if they came in to seek an alcohol license, a separate verification would be done at that time. So the request is conditional use request for a bar and commercial zoning and on-premise alcohol consumption within 1,000 feet of a place of worship. As to the criteria for the first one, general compatibility, I've broken that out. For a bar and commercial zoning, the parcels are in an area of mixed commercial and legacy residential uses. Current regulations would prevent predominantly residential uses from being developed in the area to the north and south. These parcels are fronted by US Highway 29 to the west and Old Palafox to the east. These elements, along with a future land use of commercial, indicate that this area is appropriate for this type of intense commercial use. For on-premise consumption, the agent has identified 3 places of worship within a 1,000-foot radius of the parcels, but a search by county staff using the adopted method of measurement has identified only 1 place of worship within a 1,000-foot walking distance. That place of worship is approximately 560 feet away, door to door, and separated from the proposed use by a vacant commercial parcel. There are no sidewalks in the area. The proposed hour of operation are 5 p.m. to 2:30 a.m. Tuesday through Saturday. The place of worship is approximately 560 feet away, as I said, door to door, and separated by that vacant commercial property with no sidewalks. The proposed use will be indoors and will not be visible to the place of worship. No outdoor consumption is proposed with this use, and the distance, lack of sidewalks, hours of operation, and indoor use will mitigate the incompatibility. Criterion B, this is dealing with facilities and services. Existing facilities and services are available and appear to provide adequate capacity to serve the proposed use. Any proposed modifications would be reviewed during the site plan review process for compliance with the Escambia County Land Development Code. On-site circulation. The size and layout of the 2 parcels appear to be adequate to design access and parking from both frontages. The exact number of parking spaces and location of proposed driveways will have to be determined at the time of site plan review. Nuisances and hazards. There are no nuisances and hazards associated with the proposed use found at this time that would impact adjoining properties and other properties in the immediate area. The impacts of any nuisances or hazards identified during site plan review must be mitigated through buffering. Solid waste. The operator will be required to provide solid waste services with the type and location to be determined during site plan review. Screening and buffering will be required between this use and any adjacent residential uses. The screening and buffering must meet LDC requirements. Signs and lighting. Any proposed signage and lighting will be evaluated during that site plan review for compliance with the LDC. Site characteristics. The existing site characteristics appear to adequately accommodate the proposed use. Any proposed modifications to the existing site characteristics must be evaluated during site plan review. I would add to that, while there is an existing structure on site, for them to do anything at all with this will absolutely require site plan review. Let's see. Use requirements. The conditional use as a bar does not have specific use requirements outside of the normal criteria, and the consumption use meets those specific criteria as I detailed in Criterion A. Findings: staff finds this proposed use does meet all of the criteria and recommends approval with the condition of county development review. And that concludes staff's presentation.
Do you have a proposed site plan or a preliminary site plan?
No, sir. Once again, as I said, any sort of modification is going to require a review.
Could you show us where the church is located?
Sure.
Is it on the aerial there, I would presume?
Can you go to that aerial? Okay. So I'll use the cursor on here. This is that, can you see where I am with the cursor?
Yeah.
That's the building that you can see in the photos from Highway 29 where the sign was posted. You've got this vacant property in between, and then you have a place of worship up here to the north. The measurement on the two places of worship that are to the south, both of those fell outside of the 1,000-foot distance requirement.
Will the proposed building, will it be facing Highway 29 or will it be on Old Palafox?
I would let the applicant's agent.
So they're not proposing new structures. The existing structures will remain, and it will utilize the building that fronts Highway 29. So that existing building will be rehabbed.
Could Drew, can you go back to your findings?
Which
go on down where you found it was compatible, that, oh, here it is. The distance, lack of sidewalks, hours of operation and indoor use will mitigate incompatibility.
That is correct. That is regarding those specific criteria for the on-premise consumption.
I can understand hours of operation and indoor use would potentially mitigate incompatibility. How is the distance mitigating it and the lack of sidewalks? It's 560 feet away. I kind of like your thinking on how that was arrived at.
Certainly. Let me, can you get to the zoning map? Oh, sorry. Thank you. The parcel in this case, the location of the structure is right here on this corner. As far as distance, the place of worship is up here. We do have a rather large commercial parcel in between. That is what I'm saying as far as distance. Unlike the first case before you today, in which the place of worship was immediately adjacent, this one has a vacant commercial parcel in between that is available for retail development of quite a few different types. The lack of sidewalks factors in, even when we go to measure, our door-to-door measurement, if there's sidewalks, that is the path of pedestrian conveyance that we would go out and measure along. In this case, there's not even that. There's a ditch, and you're right there on that major arterial roadway. So there's not a set approved pedestrian pathway of walking between the two uses.
Thank you, sir. We have some speakers. William Kelly. William Kelly?
He had to leave, but it's on the record.
Doris Joseph.
She wishes not to speak, but has it on the record.
Robin Joseph.
She will speak. Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. State your name and address, and you may begin.
Robin Joseph, 1830 Knight Circle, Cantonment 32533. I am representing 6 properties in the area. The 2 owners, one is my mother who declined to speak, and then my brother who had to leave for work. They are within the 1,000 feet. And I just want to mention that I recognize and fully support the research and motions that were stated in the first case earlier today. And I believe a lot of the same things still apply in this case. It's the same gravity, certainly. I do want to mention, based upon the criteria that is listed here, starting for, well, I'm looking here on my page 2, the findings of fact, and it says for a bar in a commercial zoning.
And then the very first line says it's an area of mixed commercial and legacy residential uses. And my brother and the 6 properties are the residential uses. So you might be talking about commercial zoning, but not residential. And this is not compatible with residential. And this is intense commercial use. And I understand that. And the properties for my parents and my brother, that is on the east side, on the old Palafox side, which is highly residential, even though there is some light industrial to the north of that. And then as speaking to the hours of operation here, mentioning the consumption, 5 o'clock to 2:30 a.m. Tuesday through Saturday, thinking about, and again, with respect to the findings, and this also ties in with criteria C, the on-site circulation with ingress and egress. You don't know the traffic patterns and the pedestrian patterns. My brother has a camera on one of his properties, and the pedestrian traffic is a lot. And there are children on bicycles, especially in that light residential that is on Old Palafox. I've seen it. And then as far as accidents with traffic, there is no light at 9.5 in Old Palafox, and there have been multiple accidents there at that intersection. It is not a 4-way stop. It's only 2 east-west that has the stop signs. There has been implications with power, a lot of power with poles being struck and that sort of thing. So there would be some hazards. My concern with the traffic patterns on Old Palafox specifically, not necessarily on the Highway 29. But again, thinking about those hours, 5 to 2 a.m., the 5 o'clock traffic on Old Palafox, terrible. I've seen it backed up a quarter of a mile or more. So it's terrible traffic situations, and when you involve alcohol, pedestrians, even though there's no foot traffic, again, that would be a concern. It's a recipe for disaster. And again, a lot of that is would-be, but facts are facts, as we've stated before. So we have had that precedence in the area. Thank you.
Any questions of the speaker board? Thank you very much. John Jerkowski.
Please raise your hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
John Truskowski, excuse me, 393 Gulfview Lane, Pensacola, Florida, 32507. I'm the current owner of Whiskey Runner Saloon, which is a current business on 9 Mile. We are being, actually the business or the land has been sold, so that's why we're looking to acquire this property. And if you look at our history, and I've owned the business for 5 years, we're right across the street from a ballpark. We have residential right behind us. We don't violate ordinances, the noise ordinance. We've had any kind of write-up from the police department for any issues, and no issues related to across the park. We run our business correctly. You know, we're out to do what's best for the public. My bartenders are highly trained. They cut off people if they drank too much. We have also gotten taxis or, you know, public transportation for them if we see that they've not able to drive their vehicle. And if you look at my history, I have several bars in Pensacola. This is not the only one. This property also, talking about Palafox, the road that accesses Palafox is a very undeveloped road. The likelihood of people going back through there, and me myself, I'd be willing to take that road because I own all that property and take it out of the county's hands and be able to cut it off from the bar so they couldn't access the Palafox because the county's not taking care of it now. And like I said, the likelihood of somebody actually going down that road, I can't see it because at night you can't even see that road. It's not well lit. It's hard to see. But, you know, I'm looking forward to the new area because I'd like to develop the building. The whole area out there it's an unoccupied building. There's no use for it right now, and I don't think we're going to impact anyone. They don't even know we're there. We are good neighbors. Thank you.
Thank you. Any questions of the speaker board? Seeing none.
I do have a question for the applicant. The radius zoning map shows 2 parcels. You're only talking about developing the northern parcel?
Yes, what it is, there's an RV park behind it, which I would also acquire. And yeah, I just want to clean it up. I mean, it's been, you know, it's not to the potential it has for that type of property. So I'm looking to improve that, but not add it to the bar. The bar's the front section only.
The south parcel is not, you're not planning on
No,
developing that
no,
at the
no,
moment?
it's going to stay an RV park, just as its own.
Okay. Drew, I have a question for you on that matter.
Yes, sir.
If anything other than the application's request is made, he would have to come back if there was to be development on the second parcel and the south parcel?
Yeah, so what was submitted was both parcels. Bear in mind, the structure that's there, they will be required to add parking. Adding parking means you're adding impervious surface, which means we now have stormwater review that's coming. Access management will be reviewing regarding that right-of-way. So, yeah, for that change of use to open this as an entertainment-type facility, absolutely.
So it's possible that both parcels would be affected?
It may well. It's just at this point, we're going off what we've been given.
Okay, but again, once you get the site plan or proposed site plan, then you work through all those details.
Yes, sir. Anything, I mean, it could be as simple as down to, location of the front door, because our then measurement when they seek an alcohol license is going to need that very specific requirement. I wasn't as concerned with that on this because I could clearly tell at only 550 or 60 odd feet from that place of worship, no matter where they put the door, they were still going to fall within that 1,000. But we will need those specifics at that time.
All right, thank you.
Drew, I have a question too. If this application is granted, this is going to be limited strictly to inside consumption of alcohol, is that right?
Absolutely. They have in their application, so the request to do this and have that alcohol is part of this whole request, and we have on record their hours of operation they want to have and the fact that it would only be indoors.
No takeout, no package store, no
That would be-
drive-through and all that.
That would be a different license through the state. If this board were to approve this today, your approval is going to be based on what has been submitted, and they have imposed those conditions upon themselves.
Would that come back to us if there would be an expansion of the use then?
No. Once the use is approved, any kind of expansion of the structure would be handled like any other structure. The use itself, if it were approved today, would be approved. If they were to, I don't know, seek a different kind of alcohol license, then yes, we would be back. Yes, sir.
Okay.
Do you have an aerial map?
Yes, sir.
If I'm not mistaken, there is a restaurant on the corner of, I think it's 9.5 and Pensacola Boulevard that serves alcohol.
I've at 9.5 and Pensacola Boulevard, I've got a, just looking on Google's, they've got Dave Howell Tires on the south, pressure washing business on the north side. The other side, the west side of Highway 29, you've got a church at the south and some other sort of business on the north, but I don't see a restaurant in that location.
Okay. All right, thank you.
Yes, sir.
You have shown that you do not wish to speak, but your input is duly noted. Dustin Gilmore and Patricia Gunter. Does the
Drew.
applicant like to make a closing statement?
Mr. Chairman, I had one question. Where are the homes that were in this area on the aerial? I was just trying to figure that out.
Yes, sir. You've got some up here. There's one on this back parcel here. If the speaker would like to come up, and maybe she could help, since they do own multiple properties within that area. Yes, ma'am.
Be within the circle one, so is it the next, I can't. 21?
Oh, I'm sorry.
So there, 9 1/2 mile road, whenever you're going into, and again, it was better on the other one, but this one shows it where, it's going east 9 1/2 mile road. And you'll see it makes the one in orange HDMU, and then it has the arm that goes out
Yes.
with frontage onto Old Palafox, and then my brother is, on 9 1/2 mile road. Yes.
Thank you. I appreciate that. And in addition to what she had pointed out, I was saying to the north of this on Old Palafox, there are residential uses there as well. Thank you.
Okay. Thank you, ma'am.
As to the residence on the property itself, the applicant will actually own that as part of the purchase, so that won't be an issue. So we would just reiterate that we've met the criteria of the code and ask that you approve the conditional use. It is, as you can see on the zoning map, an area that is zoned commercial. It's surrounded by heavy commercial, light industrial. There are a lot of warehouses and commercial uses. The use is consistent with the area, and, you know, we'll rehab the property, bring the property up to standard. So we would just ask that you approve the conditional use, and if you have any other questions, I'm happy to take those.
Any questions, board members of the applicant?
You stated that it's compatible with warehouses and commercial uses in the area. Are they open at 1 a.m. and 2 a.m. in the morning, those warehouses?
To be honest, I don't know. I mean, I doubt it, but I'm not sure what, I mean, a warehouse could be open 24/7. I'm not sure.
Okay.
Right.
Board members, any other questions? Thank you, ma'am. Any questions, staff or the applicant? If not, Chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go through all the criteria and address them specifically. Chair will now entertain a motion.
Mr. Chairman, I move that we adopt staff's recommendation.
We have a motion by Marty Shack. Do we have a second?
I'll second.
We have a second by Ross Padden. Those in favor signify by raising your right hand. Passes unanimously.
Sorry. 5-0 with one abstention.
She recused herself.
Yes. Just saying.
Next meeting, April 19th. Supper will be served.
Board, I just wanted to advise Ms. Bass, with your form, since it has not yet been filed with the clerk, then you have disclosed orally that you have a conflict, and per the instructions, since you've not made any attempt to participate, nor have you voted, you must complete the form and file it within 15 days after the vote occurs, with the person responsible for recording the minutes, which would be Rachel. And Ms. Rachel must incorporate the form into the minutes. A copy of the form must be provided immediately to the other members of the board, and the form must be read publicly at the next meeting after the form is filed, and that being what comes below, which is the disclosure of local officers' interest. So that's, for the instructions of the form, what must occur.
Without objection, we're adjourned.